Good morning, everyone. Welcome. My name is Eric Esteves. I'm the Executive Director of the Lenny Zakim Fund. Today is our seminar on employment law for nonprofits. Our speakers today are Mark Irvings, who's an arbitrator and mediator, who has since 1975 devoted his practice to alternative dispute resolution. And also, Mark is joined by Danielle Letterman, who's a labor and employment attorney at Bowditch and Dewey, LLP. Mark is also a board member of the Zakim Fund. And with that, I will turn it over to Mark and Danielle, who will be leading this seminar on employment law.
Okay, thank you so much, Eric. And I'm delighted to have Danielle joining us in this presentation. The genesis of this seminar was site visits that I was involved in actually before I got on the board as part of the grant making process. And it became apparent that Lenny Zakim grantees are often small organizations, are almost always small organizations that don't have the structure of human resource department usually, but they still are faced with compliance of the multitude of employment laws. And it's so much easier, it's better to be in compliance, knowing the laws, than to deal with problems for not being in compliance. So we've run these seminars for probably 10 years now. A forum where we can begin the process of educating the grantees about applicable laws and to give you a chance to ask questions as topics are covered. This is supposed to be interactive. We want to make sure that your concerns get addressed, your questions get addressed. So feel free while we're going through this to either put something in the chat, a question, or even to take yourself off mute and interrupt, because this isn't of value if it doesn't answer your questions. So we're going to start off by going through, Danielle, you want to put the agenda up?
Sure.
Great. So Danielle will cover the hiring process, which is the beginning. I will then go through employee classification, supervision, and discipline. Danielle will take you through the rest of these topics. Hopefully we'll get through them. We will make sure that near the end that we leave some time for people to raise questions that we haven't addressed. So with that, Danielle, why don't you take us away start us off on the hiring process.
Absolutely. Thanks, Mark. So hiring tends to be one of the most problematic areas in employment law because employers need to really be careful about making promises about terms of employment, conditions of employment, the length of employment that they don't intend to keep, because you can be held to those promises. So an employer's goals in hiring should be to select the best candidate possible, comply with all the laws that are applicable to the process, and focus on maintaining your ability to terminate an employee at will. So here on this slide, you'll see some sort of tips and best practices for hiring. You want to start by controlling the hiring process as much as possible. For instance, have a job description ready before you're actually even advertising for the position. And you want to make sure you're reviewing and updating your job descriptions regularly, just to make sure that those job descriptions are accurately describing the position. You also want to know what you can and can't ask in the interview process, and we'll cover that in a little more detail. You want to sort of create some sort of guidance for yourself, for your organization, so that you can ensure your interviewing is consistent and lawful from candidate to candidate. You can also consider whether there's any need for any sort of pre-employment background checks when you're undertaking the hiring process, and you want to ensure that if you're conducting background checks, that your background checks are also legally compliant. You want to be very cautious and calculated in terms of the interview questions that you're asking, and aim those questions at the specific skills a candidate needs for the job. For instance, focusing on questions that relate to the essential functions of the job and not sort of going down a path of more personal questions that might not have anything to do with the job. Finding out how the candidate might handle different scenarios that help demonstrate the need for certain skills. Questions like that are also really helpful during the interview process. You can always remember to look within your own organization for job applicants and try to the extent possible to keep your interviews consistent from one candidate to the next. Also check employee references and consider whether you want to implement any sort of evaluation or probationary period when you're hiring a new employee. You always want to make sure you're careful to document the reasons that you're selecting candidates carefully during and after the interview process. That helps to help employers down the line should there ever be any issues with why a certain candidate was chosen. If you've documented your objective reasons and those reasons are lawful for the candidate, that can help you down the line. So both federal and Massachusetts law require and prohibit certain questions during the hiring process, and you want to make sure you know and are familiar with those rules. So in order to know what you can and can't ask about during an interview, we can start by going over what's called the protected categories. These are characteristics which are legally protected. So in the hiring context, that means characteristics you cannot use to make your hiring decisions. And more broadly, these are categories that are protected from employment discrimination and retaliation, whether that's in the hiring process, in terminating an employee, and sort of everything in between in governing the employment relationship. So you want to make sure you know the protected categories. This is a list of the protected categories under Massachusetts state law. There can be some variance from state to state, but this covers everything in Massachusetts. For instance, on this list, you'll see age. Age is a protected category only for employees that are over 40. But you also see protected categories you're probably familiar with: race, color, gender, pregnancy-related conditions, gender identity and expression, sexual orientation, national origin, ancestry, religion, age, as we mentioned, military status, physical and mental disability, and genetic information. Those are the protected categories under Massachusetts law. So as a general rule of thumb, you don't want to ask anything that could reveal a characteristic that you're not going to be legally allowed to consider when you're making a hiring decision. So you shouldn't be trying to solicit that information or use it to make your decision on who the best candidate for an open position is. So in order to get at the more subjective qualities or characteristics needed for a job, you want to use performance measuring questions. For example, explaining how this particular job is one in which several tasks could come to the employee all at once, and finding out how the employee will be flexible or be able to prioritize different tasks. You can ask the candidate how they would do that. How have they done that in prior jobs, rather than focusing on any of these protected characteristics. And we'll go through some different questions and interview do's and don'ts now about what you can and can't ask in the hiring process, which relate to these protected categories.
Danielle, quick, we have two questions. One is from Mona. Can we update the job description after hiring?
You can update the job description regularly, but in terms of making sure that you're hiring candidates and both the candidates and the business understand what the expectations are for the employee in their work, it's helpful to have done that at the beginning so that all of the candidates see what those job requirements are, and that's how you're measuring each of them, rather than necessarily doing it right after, trying to sort of tailor the job description to the candidate you ended up hiring. That isn't to say that, an employee you've had in a positions evolve over time. You can definitely always go back to a job description later and edit and update them so that they're accurately matching what that person is doing. But in terms of timing, you want to make sure you have an accurate job description for what you're looking for at the beginning, rather than ending up sort of tailoring it to the candidate you've already hired.
Thank you. And then the second question, and she may want to ask it herself, but what's written is, would you mind letting us know for each rule which size organizations, for example, number of employees, that they would apply to if there is an applicable minimum number?
Yes, absolutely. And we will definitely, especially when we talk about some of the leave related laws a little later in this presentation, we'll be talking about what size organization each law applies to. Generally, when we're dealing with Chapter 151B is the statute in Massachusetts that covers discrimination in these categories. That's generally employers with 6 or more employees. However, there are other laws in Massachusetts that can cover smaller organizations. So really, when it comes to these protected categories, all organizations should be on the lookout to avoid discrimination against individuals for these protected characteristics.
Thank you.
No
Those are all the
problem.
questions so far.
Okay, great. And definitely keep them coming as they roll in. So in terms of interviews, do's and don'ts. So here we're looking at a list of topics to be aware of during the interview and hiring process. So the first one is education. So questions regarding a candidate's education or training are acceptable as long as there's a business reason for asking those questions. However, an employer shouldn't require necessarily a higher level of education for the job than the job really needs. So you want to make sure you're tailoring the job description and what you're looking for education that's actually necessary for the job. Similarly, so with marital, family status and pregnancy, those can sort of go together. You cannot ask questions regarding marital status, pregnancy, future childbearing and children, whether someone has kids or is planning for kids, or questions about childcare. You want to avoid those topics in the interview process. And the reason we're talking about some of these topics you want to avoid is you don't want to leave a candidate, especially a candidate who doesn't ultimately get selected for a job, with the impression that any one of these characteristics is why they weren't selected. So if you're talking to a candidate about their children or their pregnancy and trying to figure out how you'll need to adapt for that, the candidate might sort of rightly think that that's something being taken into consideration as to whether or not they should get the job over a candidate who doesn't necessarily have those same conditions, for instance, pregnancy. So that's why we're talking about these topics. And really, these are the things you want to avoid soliciting the information from the candidate in the interview process, because you're trying to make objective decisions that aren't based on any of these characteristics. So for instance, with disability, you cannot ask if a person has any disability. You also can't ask about whether they've made previous workers' compensation claims, but you can ask whether an applicant can perform the essential functions of the job with or without some reasonable accommodation. And we will discuss reasonable accommodations in a little more detail later during this presentation. But it's different than saying, do you have a disability? What is your disability? Tell me about it. We're not so concerned as to what the disability is, so much as how does that require accommodations, or is there something they need to be able to perform the essential functions of their job? Can they still do that with or without reasonable accommodations? That's what your focus should be on as an employer. And you can inquire whether or not an applicant can meet whatever your requirements are as a business in terms of work hours, overtime hours, attendance policies, as long as you're focusing on the needs of the job, rather than, again, trying to get to, does the candidate have a disability? What is it? And trying to solicit more information there. As the employer, you really just need to know what do they maybe need from us in order to be able to do the job or not, rather than digging into the more of their medical information.
Okay, Danielle, a lot of the same considerations apply to the different categories, but salary is something that's a new issue. Maybe you could touch on that.
Sure, absolutely. So salary, so in Massachusetts, employers are prohibited from screening job candidates based on their past wages. So what that means is you can't ask applicants about their wage or salary history prior to extending them an offer of employment. If the candidate voluntarily shares that information with you and you haven't asked for it, then you can, to the extent you're doing employee reference checks, confirm an employee's salary history, but you cannot sort of affirmatively try to solicit that. And where that law comes from is trying to sort of ensure minimalization of the gender pay gap and differences in pay. So basically the law exists because studies were finding that candidates, especially women, especially people of color and women of color, were getting paid less. And often during the job interviews, when you find out an employee's previous salary, you might make a lower offer depending on what that salary was and still be competitive. So for that reason, employers cannot ask about salary history in Massachusetts.
Okay, great. So shall we move on to what would you do?
Sure.
There is one other
Go ahead.
question.
Okay, great.
We will get to the termination issue.
Okay. Okay.
Thank you. Thank you, Mona.
Sure. So let's try by going through an example. Hopefully this will feel a little more interactive and a little more exciting than just us talking at you. So in this example, you're interviewing Mel for a weekend position. Mel mentions in conversation during the interview that he's active in his church. What can or should you ask him? So we'll do a role play here. The setting's about 3/4 of the way through an interview. I'll play the interview, and Mark, if you don't mind playing Mel.
Certainly.
So I'll start and I'll say, so Mel, how was your weekend?
Oh, my weekend was great. I was at my church on and off on both Saturday and Sunday. We just had a lot of activities.
Oh, really? So where's your church located?
Well, it's about an hour from my home. You know, it's a bit of a trip.
Oh, wow. So how can you possibly work on the weekends for this position then with all of that religious stuff going on? And so
Oh, am I going to sue
controversy.
you? Yeah.
So what should I, as the interviewer, have asked there? So we started talking about religion, right? And getting into what Mel liked to do. It would have been better for me as the employer, rather than sort of following Mel down the road about, tell me more about your church. It would have been better to focus again on the job qualifications you need, not the information you don't. So something along the lines of telling Mel, well, the hours of this position are, Saturday and Sunday from 7 to 2. Can you do those hours? Understanding that he might have other commitments. But that's a really important distinction that you want to, even though Mel's the one who's bringing it up, you don't want to, as the employer, sort of take that bait and follow it down that road. This is information you don't want to be considering in terms of whether or not you hire a candidate. So focusing again on the job qualifications you need and focusing on whether or not Mel can meet those qualifications. So we can also try another example next, if that makes sense. So here you're interviewing Heidi for a job as a receptionist. Good attendance is a must. During the interview, Heidi mentions that she's 5 months pregnant. So what questions can you ask Heidi about her pregnancy, maternity leave, and or her intentions after the baby arrives? So we'll say this is about halfway through the interview. Mark, if you'll be the interviewer, I'll play Heidi.
Okay, so Heidi, when are you available to start?
Right away. I'm 5 months pregnant, as you can probably tell, but I'm ready to begin.
Oh, wow. No, I didn't realize you were pregnant, or at least that pregnant.
Yes, I am, but it won't cause any problems.
Well, yeah, new child. Are you sure you're going to be able to be here on time?
Oh, yes, of course. I'll definitely be on time.
Okay. Do you have childcare arrangements, or what do you think your schedule will be after the baby? What have you arranged?
I don't really feel like I have to tell you all of that, at least not yet.
Oh, yeah, yes, you do. I've dealt with new mothers.
So, and seen. So what should Mark have said here? It would have been good for Mark to really have focused again on what he needs from a candidate, rather than focusing so much on Heidi's pregnancy, how that's going to impact them down the road. Keep in mind, this is still just that initial interview. So for example, if Mark had said something along the lines of, I need you here at 8 a.m., 5 days a week, and reliable attendance is really important. Can you do that? That's again, sort of pivoting back to the job qualifications and what you need from an employee. You don't want to do what sort of happened in this example, where you're giving Heidi the impression that the hiring decision might be impacted based on her pregnancy.
And if I might, this, I've dealt with this in my role as a mediator in a lawsuit. It's particularly difficult for small organizations when you have just a couple of staff members and somebody walks in conspicuously pregnant, and your reaction is, this is not going to work. You know, we don't have enough people to be able to cover this absence. So it's the type of thing you have to be extremely careful about as to what you say in the interview, because it can come back to bite you.
Absolutely.
So are there any questions regarding hiring that we have not yet touched on that you need us to address? Anybody? No, okay. Well, we'll go on to employee classification. By employee classification, I mean, is the person an independent contractor, or is it an employee? Also, is the person exempt from overtime under both the Fair Labor Standards Act or the Massachusetts laws, or are they non-exempt, meaning they are employees who are entitled to overtime? Just as an aside, an exempt person, just because they're exempt doesn't mean they can't be salaried. It's a much more complicated topic than I want to get into now, but just because you're salaried doesn't mean you're automatically exempt. So the employee classification is a very hot topic in the wage and hour law. It is the source of much litigation. It affects delivery drivers like Uber, Lyft, DoorDash. It affects IT people. It affects remote editors, grant writers. It affects strippers, which is not an issue here, waiters, salespeople. But so it's a very major source of litigation now. I won't get into all the ins and outs of a classifying exempt, non-exempt, but understand that particularly under the mass wage law, if you have, for example, said someone's an independent contractor, they're really an employee. If you get this wrong, there's treble damages plus attorney's fees. I had a situation in mediation with a small organization, two wonderful women who had a program dealing with empowerment classes for women. They had a total budget of about $125,000. One of their board members, who was from a big law firm but did corporate law, said to them, you know, these teachers, you could save a lot of money if you called them independent contractors, then you wouldn't have to pay their payroll taxes and the other benefits. So they changed the teachers to independent contractors. Teacher, a long-term person, ultimately got terminated. She went to a lawyer. The lawyer and said to the lawyer, I was unfairly terminated. And the lawyer said, well, unfair is not illegal. And unless you have a contract that talks about just cause, there's nothing I can do. But let me see your pay stub. And the lawyer looks at the pay stub and said, you're an independent contractor? Oh, no, you're an employee, and brought suit. The case wound up being settled for $75,000, which was more than half of this organization's total budget. It was devastating. So it's really important that you get it right. So let's go to the employee versus independent contractor slide. Okay, Massachusetts chapter 149, Section 48B. It is a very strict law. It's one of the few in the country, although now California has adopted it by judicial decision. It's a three-part test as to whether a person is an employee or they qualify as an independent contractor. And to be an independent contractor, you've got to satisfy all three prongs. The most difficult prongs, so the first one is the person free from control and direction, meaning an independent contractor is really supposed to be someone who has this specific expertise, and they're not, you can't bring someone in and then daily supervision the way you would with an employee. The second one is the toughest. Is the service performed in the usual course of the business? So you're providing direct services to a particular population. You have someone who you bring in and they are providing services to that person. They are, even if it's part-time, whatever, they are an employee because they are doing the work of your organization. If you bring in an electrician to fix the lights in your office, that person's an independent contractor because you're not in the business of providing electricity. The third thing is, do they have an independently established trade, profession, occupation? Do they do this just for you? Or do they have a business that they're going to 30 different places in a week and performing it? It would come up in your types of organizations with things like a grant writer who you hire for a specific project to write a grant. You're not in the business of writing grants. Your grants are essential to you getting it. You don't need a person all the time. Now, if it's someone who's just working for you, just writing grant proposals, they are part of your organization. They're going to qualify as an employee. But understand there are different categories of employees. You can have a temporary employee. You can have an employee, certainly part-time. You can have an employee that you hire just for a project. But if they are doing the work of your organization, they are an employee. Please do not make that mistake. Okay. Going down to the next slide. Interns and students. As I've laid out there, the primary beneficiary test, and I won't read through all the elements. Typically, in a not-for-profit, it's fine to have an intern, but it's important that it's a specific program. They are there essentially for their benefit. They can't be replacing other people, your full-time staff. And if it's part of like a college program that they get some credit for it, that's even better. But don't have people who are doing your regular work and have an expectation of they're going to have a job. Don't call them interns and think that you are safe. Now, there's also the question of payment. You can't have regular payment for the interns. If you start paying them, other than there may be a gift, I think it's something like $500. Are you familiar with, Danielle?
Yeah, it's definitely something like that. I don't remember what the threshold is, but it's close to
You know, if you say at the end of the program, you know, you give them a gift of $500, whatever, that's okay. But if you're giving them money on a regular basis, they're going to be deemed an employee. Okay, next, the next slide, please. Okay, volunteers. If you are a for-profit enterprise, you can't have volunteers doing the work. If you are not for profit, it is recognized that you can have volunteers, but again, they can't be displacing regular employees. They can't be, full-time. They can't have an expectation that they're going to be getting paid. So it is fine, again, as volunteers and not-for-profit. What you can't do is have your employee, let's say the employee works 40 hours, and then you have a program on a weekend. And the employee says, oh, well, I'll volunteer to do that program. You can't have employees volunteer in the same place to do the program. So it's a way that places, or if you have two sites, you can't have the person work at one site and then be a volunteer at the other site. All those hours are going to be considered compensable time. So if it's a true volunteer, you're great. If it's a subterfuge to get around paying people, you could be in trouble. Again, treble damages, and if it's overtime, it adds up very quickly to a lot of money. Any questions about interns, volunteers, or employee classification? Okay, let me get my cursor down to the question. Danielle, do you see the question?
Yes, is it if you give money to an intern at the end of their internship, is the money given to them taxable?
Do you have an opinion on that?
No, at that point, I usually refer to a tax lawyer and specialist that way.
Yeah, I'm not positive. We can try and get you an answer and send it to you. Okay, any other questions? Let me go back up.
There was a question about collecting info on race, ethnicity. There was one about the founder of an organization being paid and the acceptable or not.
I think that goes to you, Eric. The one about a founder of an organization getting paid.
I guess I don't know.
Yeah, I mean, I think most organizations, the founder is an employee, and to the extent that they're getting a salary, that's pretty typical of an organization. I don't, certainly the fund has never required that founders be volunteers. But going up to the one about collecting information about race and ethnicity, Danielle?
Yes, so you can maintain and track that information, but you need the employee's sort of voluntary self-identification. So you can't require that an employee provides it. There needs to be an option that they do not answer. But that is information you can have and collect. But it's not something you want to be asking about sort of during the interview process and acting like that's something particularly that's important for the position. So rather versus just tracking it generally in terms of your organization.
Okay.
There were 3 other questions. One around giving money to an intern at the end of the internship. Is that money to them taxable, or do they need a 1099?
Yeah, that's the one I said. We need to check with a tax attorney, and we'll send that answer. Maybe, okay. Eric, if there's a way for you to disseminate that once we get the answer.
Yep, certainly. And then 2 others, one about a STEM program that performs a class, and at the end there is a stipend, and another stipend question if you give stipends every now and then to volunteers, is that allowed? So infrequent stipends to volunteers.
Danielle, you want to?
Yeah, I mean, I think sort of just going back to Mark, what you said earlier, the focus is going to be, you know, does it come with such frequency that the stipend is really a version of paying the volunteer more as an employee, or are they genuinely a volunteer, and whether or not that stipend meets the threshold or exceeds the threshold. So I mean, if you're paying someone a more significant amount of money with some frequency, I mean, I see the question sort of says every now and then you might be showing really that the person's a little more of an employee than they are a volunteer.
So the question about the STEM program, are these students who go through a STEM program, and if they complete it, they get a stipend?
Yep. So just, yeah, so we're working with someone, and they're finding it difficult to get youth from ages 13 to 18 to come, but offering them an incentive at the end, like after they learn, you know, this, after they go through this like 8-week class, there would be a $200 stipend. So it's a way of getting youth to come to the program and learning. So.
Danielle?
So I'd say generally when it's really a learning program versus them offering services to you, you're looking at more of a student relationship, which should get you more around the employee classification and obligations that come with that. It would probably require like a closer analysis of the Department of Labor standards, exceptions about who gets paid versus not, and maybe knowing a little more about the program. But generally for educational purposes, offering some sort of incentive, at least from the employment law perspective, wouldn't be an issue.
Yeah, and I think I've seen the Department of Labor opinion letter on a similar situation, and I'll try and find it and send it along. Yeah, I do have an opinion letter, which I can send along. That should give you some guidance. Okay. Supervision and discipline. Understanding that unless you give employment contracts, which is pretty rare, employees are at will in Massachusetts. They don't have a right to a job. They don't have a right to just cause protection. And the comments we made earlier, employee handbooks, sort of similar to the notion of what you say at job interviews. You want to be very careful that you don't have language in there that seems to create an entitlement to a job for any period of time or certain procedures before they can be terminated. Now, I say this from my perspective now on the ZACM fund as sort of a board that has employees as a neutral. You know, you've got to be fair, and I would recommend that you follow good procedures. But an employer can terminate an employee at will for any reason, as long as that reason is not illegal. Illegal would be for you're terminating it for one of the protected categories, or in retaliation for people asserting certain statutory rights. For example, if they say you didn't pay me overtime, and I think you should have, and you say, well, no one's going to question me about overtime, you're fired, that would be retaliation. That would be unlawful. in terms of supervision, there is no requirement in the law that you conduct regular evaluations of people. It is a good management practice to do so. But if you do evaluations, be honest. If you have a difficult employee, whether it's the evaluation that you're writing up or your reasons for termination, it's crucial that you be forthright, which is easy for me to say as a neutral looking at things. It's a lot harder. Being a supervisor is really difficult. And it's hard to say to someone's face, look, you're not meeting our expectations. But what you've got to do is be clear and set forth, these are our expectations, these are what you're not doing, and I'm documenting it when you don't do it. If you say to someone, for example, leading up to a termination, it's, well, you know, we're restructuring the position and you no longer have the needs, or we're eliminating the position, and then you ultimately hire someone and a person sues you, and they look at, for example, the evaluations, and you've never mentioned in the evaluations what they haven't been doing. It's good, 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 good. And then, yeah, but everybody knew this person was not performing, then you're in trouble. So the key, and if an employee can establish that the reason that you stated to them was pretextual, was not the real reason, that in itself in our state will be enough to establish discrimination. Not automatic, but it can be. So it is vital in your supervision, which may ultimately lead to termination, that you always be truthful, because it can bite you. You don't call something a layoff if it's really a termination. If you really don't want the person there and you have reason, then you've got to state it and make sure your records are complete. Okay, discipline. It is, everybody in a workplace is personally and emotionally involved. If someone does something that you're not satisfied with, as I said, make sure you are documenting. But it is imperative that before you take action, that you conduct a fair investigation. If it's something that you're directly involved in, try and have someone else do the investigation, a board member, someone from outside. But if someone said something to you that was offensive and you're the one that's making the decision, it's immediately suspect. You try and avoid what they have, for example, in the National Football League, where the head of it, Goodell, makes a decision, and then they get to appeal. And the appeal process is Roger Goodell gets to decide if his decision was correct or not. That's not a real process, and you can get in trouble. There is also, it's imperative that there is no need to take immediate action, even for something egregious. The better practice would be to put the person on a suspension, paid or unpaid, pending investigation. Let it calm down, be able to make a dispassionate evaluation of what needs to be done. But if someone does something and you fire them immediately, among the other problems besides the correctness of the decision is, in Massachusetts, when you terminate somebody, you've got to provide them with all the pay that's due them, including accrued vacation, if you give vacation. And if it's got to be a check on the day of the termination. So you're much better off putting a person on a suspension pending investigation, evaluating what action you want to take, and then having the checks prepared on the day that you're going to terminate somebody. It's also really important that the employee be asked about what happened, given the opportunity to respond. Difficulties in cases where first the employer makes a decision and then they conduct an investigation. Once you've made the decision, recollections change, power dynamics get into play. So again, there is no rush in disciplining people. Be intentional, be dispassionate, and document. Danielle, any stuff that you would like to add to that from the perspective of someone representing employers?
Yes, so I mean, absolutely just emphasizing what Mark said again, document, document, document. You want to be documenting your decisions, because basically when I get involved is if your employment decision ever is challenged by the employee legally, they file a lawsuit, they file a discrimination charge, the documents you have at the time are one of the most valuable ways you have of showing your reasoning versus, testifying now that, oh no, of course we didn't do it for any discriminatory reason. It helps a lot more to have contemporaneous records showing how you came to the decision and why and who was involved and when that decision happened. Like Mark said, you don't want to make the decision and then sort of backtrack and figure out why you made that decision by doing the investigation later. You really want to think through every decision. It doesn't need to be made rashly. It shouldn't be made rashly. You want to make sure it's thought through, because if this is ever coming under a microscope of a judge or a jury or a hearing officer, you're going to be evaluated in a much more rational way, and making sort of a moment decision in the moment is not going to look good later on. It will look like it was perhaps motivated by a different reason than maybe the legitimate non-discriminatory business reasons you made the decision in the first place.
Okay, a couple of questions have come up that relate to the personnel records law that implicate that. You want to explain the personnel records law, what the obligation is when you're putting something in a file?
Yes, absolutely. So an employee has a right to request their personnel record. Employers actually have a very short turnaround time. The law says 5 business days after the request, you're supposed to give them their personnel file. Now that personnel file should include basic sort of, and I'll actually move, this is perfect timing to move to the next slide for record keeping. So it should include basics like the hiring and onboarding documents that you gathered from an employee. So that would be their job application, resume, references, an employment contract, if they have a contract, information about their salary, compensation or information, the form I-9 that demonstrates their right to work in the US, information about the time they work and what they were paid, records regarding accrued paid vacation or paid sick time can also all be part of the personnel file. And this goes a little hand in hand. I saw the question, do you have to share evaluations of employees, or can you just document them to protect the company? You have to share anything negative that goes in an employee's personnel file with the employee, and they should be given a chance to respond to it. So that's one, a legal obligation, but 2, it also makes sense from your business perspective. If an employee is not performing well, you want them to know that. A lot of employment disputes that I see in representing businesses when they're dealing with employee disputes relate to unclear or non-transparent communication. And it's really an employee who gets fired out of the blue. To them, that's someone who's much more likely to make a claim, regardless of whether on the employer side you would say that you had a very legitimate reason for doing that and you've been regularly documenting all their issues. But if that employee hasn't been talked to at all about those issues, then it seems very hard from the employee's side to understand that they weren't fully performing. So it's actually in your best interest as the business to make sure your employees know how they are performing, and if they're not performing well, that you're managing their performance rather than that employee just getting a termination notice out of the blue. And that's the different ways you can use discipline and progressive discipline. So whether that's by starting with a verbal warning to a written warning to suspension. Now, you don't always have to go through each one of those steps. Sometimes what an employee can do can be so egregious it might warrant termination immediately. But you do want to have these sort of regular check-ins and evaluations so that both you as the business and the employee know where they stand in terms of their performance, and give them a chance to improve it if that's something they need to do.
Okay, and I believe that the personnel records law, which I think Claudia may have put up,
Yes.
requires actual notice to the employee of something negative going in their file. It's not just that they have the right to request a review of the personnel file, but I think you have to give notice, and the employee then has the right to submit a response. One of the questions was, can they be fired for filing a rebuttal? I think the answer is no. They have the right to submit a rebuttal. If it's scurrilous, if there's something abusive in it, then they're not being fired for submitting a rebuttal. They would be fired for, inappropriate behavior. But you can't simply put something negative in their file and they only find out that it got there after they've been terminated and request their file. There was a question about, does a small nonprofit organizations have to provide, is there an employee size cutoff on the personnel records law, Danielle?
I don't believe so. I believe it applies to all employees.
Right, and it's available even to former employees.
Yes.
Okay. There was a question about someone does something problematic off of work hours or premises. Can that be the reason for discipline or termination? Again, you can discipline fire for any reason that's not unlawful. In a just cause situation under a unionized contract, one of the things that's looked at, off work misconduct is a major complicated issue, but basically even in a just cause situation, you would look at, was there a nexus to your work? So if, for example, you're an organization that deals with students and there's evidence that a person abused a student totally away from your workplace, that would be grounds even under a just cause provision for terminating that employee, because it goes directly to their role with you. But again, I don't think any of the organizations that the Zakin Fund deals with have unionized workforce with a just cause provision. I'd like to believe from an employer's point of view, you haven't written in your employee handbook that people will only be terminated for just cause, so you don't have to deal with it. But if you do, there are legitimate business reasons, if there's a nexus to your business, for terminating someone for off-duty, off-premises misconduct. So other issues, getting back to the record keeping.
Could I ask a follow-up question?
Sure.
Yeah, so Claudia from Justice at Work, I was the one that was asking about the rebuttal.
Yep.
And I guess I'm following up because I know that there was a case that came out from the Mass Appeals Court in early January, is my understanding, that basically said that the Section 52C would not fall under like the public policy exception. And it's a case that where an individual was fired the day that he filed his rebuttal to his record. So I was just wondering if you guys had any more information on that. We're sort of trying to figure out how we can advise workers who are interested in filing potentially a rebuttal to their personnel record to maybe a disciplinary action, if that could be grounds for firing in an at-will employment.
Well, I guess so. My first reaction to that would be, so as Mark said, at will employment, you can be terminated for any reason or no reason at all, so long as it's not an illegal reason. So if you had an instance where the worker was filing a rebuttal and it raised its own sort of concerns about, hateful language or discriminatory comments about someone else, could disciplinary action be taken against the worker for sort of the content of the rebuttal more than just the fact that they filed a rebuttal? And I think that answer would be yes. If it's just the act of filing a rebuttal, which is something they're entitled to do, then I mean, legally, could an employer, we know they could, but whether or not that really, whether the personnel record statute sort of gives a private right of action to the worker for that termination. I mean, you'd also need to prove that that was why, right? Not just he happened to file a rebuttal that day and they were terminated for poor performance and we're already on a final warning or something relating to that. So it might be a little more fact specific.
Yeah, Claudia, I remember reading the case, and I'd have to go back to read it, and how much of it focused on is a violation of the statute, a public policy, termination or against public policy. I remember being a little surprised, but I would have to read it. I think it's more narrow, but I would say that an employer who says, I'm pissed off that you filed a rebuttal to what I wrote about you in your evaluation, so you're out of here. Very poor employment practice. At the very least, it's going to result in substantial legal fees for the organization. But I would have to go back and read the case itself to sort of remember why they went the way they did.
Okay, thank you.
You bet. Thank you for raising it. Go ahead, Danielle, you want to proceed along?
Yes, so these are different examples of records that employers need to be keeping. And I think we've talked about a bunch of these already. One important thing to note that can also get confusing on the employer side, especially when you're a smaller organization, medical information needs to be kept separately than the personnel file. How that's done now, whether your records are electronic or you have the paper version still. If you have paper versions, it's a little more straightforward, right? Because you can have one file that says the employee's name and is their personnel file and a different file that is the employee's medical file. But they're not supposed to be stored together. They're supposed to be kept separately. And all of this information, the personnel information and the medical information, should be stored safely and confidentially. And access shouldn't be granted to everyone. It should be kept privately, whether that's with your HR person or whoever in your organization handles that. And now we'll move on to reasonable accommodations. This is another key issue that faces a lot of employers. It can come up in the context both of employees that need an accommodation based on a physical or mental disability, and also in the context of employees who need some sort of accommodation based upon their sincerely held religious belief. And as we went over earlier, the law does prevent discrimination on both of those grounds, right? Because of disability or religious belief. And so a need for accommodation, it can come up as early as the hiring process, which is why employers always want to be on the lookout for it. Employers do have a duty to reasonably accommodate even during the application interview process. For instance, if you have a deaf employee during the interview process, you need to make accommodations so that they can still be interviewed along with everyone else. So what is involved in determining when this duty is triggered and who qualifies, we'll look at that. Sometimes it's a little easier to look through the lens of disability, but always also keep in mind as we're discussing this, that it can come up in the context of religion as well. So first, you think of notice. When do you know as an employer that this is an issue? And you want your managers and supervisors in your organization to be able to spot a request for reasonable accommodation. It's on the employee to put you on notice, the employee or job applicant, to put you on notice of the potential need for an accommodation, but they don't need to use any sort of magic words to trigger that need. Once you as the employer know that someone might need an accommodation, you need to engage in what we call the interactive dialogue. So that's really a back and forth with the employee of finding out what restrictions do they have, and is there something reasonable that you can provide as the employer to allow them to still perform their job with or without a reasonable accommodation. So it can be difficult to assess individually, but especially for bigger organizations, it's harder and harder for them to show that there's some sort of undue hardship on the business. And so basically an accommodation is reasonable if it doesn't cause the employer an undue hardship. Those are sort of the legal words we throw around in terms of analyzing whether something is reasonable or not. But a key thing to keep in mind as the employer is to don't ever reject requests for accommodation outright. Engaging in this interactive dialogue means it's a back and forth communication process with the employee or job applicant. So rather than an employee saying, hey, I need an accommodation, I want XYZ, the answer isn't from the employer, no, you can't have any of those things. Even if the employee asks for something that your organization cannot provide, it's still on the employer to assess, but is there something else that we can provide that would still allow them to do the essential functions of their job? So the only time you do not need to provide an accommodation is if it will cause you an undue burden, but keep in mind, you don't necessarily have to provide the accommodation that the employee asks for. Sometimes there are other accommodations. Sometimes if you're factoring in cost or logistics, there might be another accommodation which is equally reasonable, equally allows the employee to do the essential functions of their job, but isn't the specific one that the employee requested. And as the employer, it's your job to assess what viable options are. So for instance, reasonable accommodation could include things like making existing facilities readily accessible to employees with disabilities. For instance, an employee in a wheelchair, ensuring that they have equal access to your facility, whether it's modifying work schedules or restructuring parts of an employee's job. Some of those things can be considered reasonable accommodations. Sometimes it's acquiring or modifying equipment or devices, or adjusting training materials or policies based on the employees. And things like providing qualified readers and interpreters are typically found to be reasonable. Things that have been found to be unreasonable accommodations or restrictions would be things like indefinite leave. If an employee needs to go on a leave of absence for a period of time that is in no way specified and could be forever, that's something that could be unreasonable. Or if the company would be required to hire a second person just to help the employee do their work, that too could be viewed as an unreasonable accommodation. But it's a very, very fact-specific analysis. And the important part as the employer is that you listen to the employee, you find out what the restrictions are, and then work collaboratively with them to try and figure out if there are accommodations you can provide which are reasonable and that would allow them to do their job. So sometimes this is a little easier to understand by running through an example. So for instance, here, Celia, your bookkeeper, has been struggling to keep up with her work lately. You've also noticed she's been late to work with some frequency in the last few weeks. When you sit down to talk to her about it, she indicates that she's trying her best, but she's been having a hard time of it due to her chronic depression. So what do you say in response? So what if I say, well, if you can't do it, you can't do it. Do you think you need to resign? No, that's probably not the way you want to approach that. That's not really what you should say in this situation. Here, we know that Celia has flagged a potential disability issue for you. So that's triggering your need to engage in a conversation with her about potential accommodations and her needs going forward. So a better response from the employer would be, thank you for letting me know. I'm going to give you some paperwork you can give to your doctor so we can obtain more information about any restrictions you might have, and then work on the interactive dialogue from there. So
Danielle, is there a threshold size of employer who's required to provide reasonable accommodation?
So because reasonable accommodations are also covered by Chapter 151B in Massachusetts general laws, it's that 6 employees standard, but because there are other laws sort of equal to Chapter 151B, it really applies to all organizations. So you want to keep that in mind. And now to segue right into a conversation about leave and time away from work. This comes up a lot, and especially in small organizations, it can be hard to figure out how all of these laws come into play for your business and which ones apply to you. So do we have a question? Okay, no, that was the personal records question. Great. So this is an overview of some of the laws that exist that relate to time away from work and require employers to give certain job protected leave. Now I'm going to go through it and talk about what size employer each of these apply to. So the Family and Medical Leave Act, which allows for up to 12 weeks of unpaid leave for an employee, only applies to employers with 50 or more employees within a 75-mile radius. So a lot more for bigger organizations than smaller organizations. But in Massachusetts, starting January 1st of this year, we now have the Massachusetts Paid Family and Medical Leave Act, which applies to all employers. There are different contribution rates depending on your size, but it's a state program whereby employees can apply for paid leave for medical and or family reasons through the state and receive some compensation. And employers, depending on your size, the threshold is around 25 covered individuals or more. You might have contribution rates that you need to make. Now, some of those contributions can be passed on to the employee and some can't. We could probably talk about this law all day. It's a lot is going on with it and it's changing constantly. They just released the new contribution rates and announced that starting in January, employees will actually be able to get a higher level of benefits through this paid leave program. But it's one of the biggest paid leave programs in the country, allowing up to 20 or 26 weeks of paid leave all in if you're combining medical and family leave for employees. So you definitely want to know your responsibilities under that act. There are different notice requirements, and if you meet the employer size threshold, you'll also need to be making sure you're making contributions according to the law. There's also the Massachusetts Earned Sick Time Act that applies to all employers, but only employers that have 11 or more employees have to provide that sick time paid, and that's up to 40 hours a week. And there's also actually, now there's the Massachusetts COVID-19 Emergency Paid Sick Leave Program, which we have, which means you have to provide 40 hours of paid leave up to the amount of $850 per week, beginning May 28th of this year and now running through, it's just been extended till April 1st of next year for different COVID related reasons. There's the Massachusetts Parental Leave Act, which provides unpaid leave for both partners who have given birth to a child. So both maternity leave and paternity leave are included in this law. And that applies to employers with at least 6 employees. The Massachusetts Small Necessities Leave Act applies also to employers who qualify under the FMLA, the Family and Medical Leave Act. So that's for employers with 50 or more employees, which also goes for the Massachusetts Domestic Violence Leave Law. The Massachusetts Jury Leave Law and Veteran and Memorial Day Leave, that applies to all employers. The rules are different based on private or public employers. And then military leave, there are obligations both under state law and federal law to provide military leave to active military members. So there's a lot of different laws that might apply to your business. And you want to make sure as an employer that you understand all of them, understand which ones are applicable to you when an employee is looking for leave and time away from work. Another important thing is to always review your employee handbook, and we'll also talk about employee handbooks a little more later. Make sure that your business policies are consistent with the state and federal leave laws that are applicable to you. And some of those have been updated and changing more recently. So there are several different types of leave available. So that's just a brief overview of many of them. So for a little more fun, we'll try an example here. So we have Donald, who recently started working for your business, and he calls right before his shift to say he's going to be late because one of his daughters is sick and needs to go to the doctor. You tell him that that means he's going to receive a warning in his file for being tardy, and you require a doctor's note. Did you do the right thing? So in this scenario, we would turn to the Massachusetts Earned Sick Time Law. And that law specifically specifies that a company can only require documentation in certain circumstances. So just because he called out right before his shift doesn't necessarily mean that Donald can be asked to provide a note from his doctor. There are very, very specific requirements about when you can ask for that documentation and when you can't.
Danielle, there was a question for Mona before on the prior topic. Do you see it about a threshold?
The threshold is 25 employees for the state program. I'm assuming, Mona, and you can correct me if I'm wrong, you're talking about the Massachusetts Paid Family and Medical Leave Program. That actually applies to all employers, but whether or not you as a business will need to make contributions to the state program depends on how many covered employees you have, and that threshold is 25, and that can change the contribution rates. Basically, if you're under 25 employees, you can pass on most of the contribution requirements to the employees rather than as the employer having the responsibility to make the contributions yourself. But those numbers and all have recently changed now, going into effect January of next year. So if you're not familiar with the program, or your organization might need to make sure it's given out the notice to employees and is making the proper contributions to the state, we can definitely talk about that further, and that's definitely something you want to look into as a business, because it's a very new law and very important that all employers are following it.
Okay, thank you.
No problem. And now we'll talk a little about employee handbooks. So as an organization, you want to think strategically about employee handbooks, because as Mark said, they can cut both ways sometimes, because they can create some legal exposure. Basically, you want to make sure there's no policies in your handbook that your organization isn't following. So it's not a place where you want to put wishful thinking. You don't want to just copy a handbook from your last job or something you found online. You want to make sure it's really tailored to your organization and how you are doing business. Handbooks are different from operations manuals and vision statements. They're really information for your employees to understand how policies are being implemented. So under Massachusetts law, there is a risk sometimes that handbooks could be deemed an employment contract. And for that reason, it's so important that there's nothing in there that isn't true about your organization, because businesses don't really get to have it both ways. You can't expect employees to follow the handbook while holding yourself sort of exempt from your own policies. And just a general fine print disclaimer sometimes isn't enough to protect you from an employee saying, oh, this handbook gives me contractual rights because you said you would do X, Y, and Z. Here it is laid out in the handbook. So that's why it's very important to make sure your handbook is accurate. We actually recommend revisiting your handbook and regularly updating them about once a year. To the extent your handbook lays out how you will discipline employees, make sure you're protecting yourself from having to go through certain steps. So as we were talking about progressive discipline earlier, you might say typically employees get a verbal warning and then a written warning and then suspension and then termination. You want to also reserve your right in that policy to move right to termination where an employee's conduct warrants it, and not necessarily make yourself have to stick to every step of what might be possible in a progressive disciplinary policy. So you really want to include some express statements in your handbook and throughout the handbook that you're not creating an employment contract with the employee. You're just trying to let them know about the policies. You want to avoid, like Mark had said earlier, using terms like just cause or fairness. Don't change that sort of at-will employment relationship to something where the standard is much higher for you to be able to make employment decisions in your organization, whether that's termination or hiring or what have you. You want to avoid necessarily disciplinary procedures that you won't follow. If you have a policy saying every 30 days or every 90 days, employees are going to get full evaluations on their performance, you don't want that policy in place unless that's actually happening in your organization. And sometimes you might say, oh yes, annual performance reviews, we will always do them. Before you commit to that language in a handbook, you want to make sure that that's definitely happening, or indicate it's something you strive for, but give yourselves more wiggle room on whether or not that's actually going to be what happens. And so this slide is really just to give you a better idea of some things I would recommend including in a handbook. Anti-harassment and discrimination policies, policy on the Massachusetts Earned Sick Time Law and how that works, notice about the Massachusetts Pregnant Workers Fairness Act, the safe harbor for deductions from exempt employees. You might recall earlier in this presentation, Mark talked about employees who were entitled to overtime and employees who weren't entitled to overtime. And for those who are exempt, therefore not entitled to overtime, there's certain language that can protect you as long as you're ensuring those employees aren't having their salary reduced for any reasons outside of very specific legal exceptions. If you have a vacation policy, you want to lay that out in the handbook, especially if you want to use a use it or lose it policy, meaning that an employee has to use all the vacation time by the end of the year or their anniversary date or something like that. You need to lay that out specifically within a policy for you to have that policy in place.
And I
Otherwise,
jump in here on the issue, if you have non-exempt employees and who are entitled to overtime, you probably want to include a provision that says that overtime must be worked with authorization.
yes.
You don't want a situation where people can help themselves to overtime because the standard is if they work or you suffer to allow them to work. So if an employee works overtime, even though you didn't tell them to, but you knew about it, and you're liable for it. But if it says you need authorization to work overtime, you maintain a control over the hours and what it's going to cost you.
Absolutely. And I see we just got a question. What's the difference between exempt and non-exempt employees? So when we're using that term, we're using it in relation to overtime. So exempt means you're an employee who is not legally entitled to overtime, and non-exempt means you are legally entitled to overtime. We could probably spend several hours talking about how you classify employees in those ways. And I definitely always recommend seeking legal counsel to make sure you're making those decisions properly and in accordance with the law, because it can be very expensive for your organization if you make the wrong decision on those.
Okay, going back, apropos to that question, we were asked if, actually by Juliet, if you've done something wrong in the past, what do you do moving forward? If you can correct, if you didn't do it right, you can correct it paying back the money that you should have. For example, if you should have paid overtime and you realize it, and you can go back and pay it, what you would want to do is make sure you pay it before there's a lawsuit. Because if they go, and there's a procedure for violations of the Wage Act, people have to first generally go to the Attorney General's office, file a complaint, they get a right to sue letter. But if they get to the Attorney General's office before you have made a payment correcting it, they are entitled to treble damages. If you pay money that was owed before an employee makes a claim for it, there is no treble damages. Arguably, there might be interest on the money if it was owed, but it's the treble damages is the killer. You know, it's, if you recognize that you have a problem, it's something you should coordinate with a lawyer on and a lawyer, if I might say, who does employment law. Getting a lawyer who does housing or who does corporate as your advisor gets you in trouble. And it's then difficult, you don't want to be in malpractice suits because someone gave you bad advice because they didn't really know the law. So I believe the ZACM grantees have access to DLA Piper. You may have other people who you have access to, but if you realize you have a problem, you should get a lawyer, speak to a lawyer to see how you want to handle it. Danielle, you've no doubt represented employers who have discovered. How do you generally have them handle it?
Yes, no, I agree. Once you realize there is an error, you want to address it as early as possible, because the second that the employees figure that out and take some sort of legal action, you're on the hook for that treble damages, which is 3 times as much as you owed to begin with. So say you realized you didn't pay an employee $1,000, the second that lawsuit gets filed or the attorney general complaint gets filed, that becomes $3,000 automatically.
And attorney's fees. And
even
if
fees,
it's,
expensive.
$3,000, that's not that big a deal, but it could take $50,000 in attorney's fees, and they're entitled to those fees because it's sort of a public policy of enforcing the wage laws. So it could be a really big hit. You're much better off addressing it when you realize there's a problem.
Yes, absolutely. I completely agree. And I thought I saw a question about handbook and how to address it. So these policies I've listed to include in a handbook. I suggest including them in the handbook because there are certain policies that need to be in writing somewhere. So you might as well compile them together and make them easily accessible for employees. And this list is the policy. This is a list of policies you are legally required to have. Keep in mind though that the FMLA and the Massachusetts domestic violence leave law only apply to employers with 50 or more employees. But since they need to be in writing somewhere, an employee handbook can be a good place to have them all together. And again,
okay. I'm sorry, Danielle, go ahead. I was just going to say, you might want to jump to the discrimination harassment complaints.
Yes, perfect. Absolutely. I'll jump there right now. And then just for your reference, and we can make sure you guys all have these slides and materials. This slide just shows a sample table of contents for things to include in a handbook. And we recommend updating them every year and reassessing what you use and don't use and checking out new laws or developments and changes. So now very briefly to address handling discrimination and harassment complaints. You want to make sure you have a policy in place. You should legally, and it helps you create a defense. And you want to make sure you're clear about how you're defining discrimination and harassment, and that you're covering all of those protected categories that we said earlier on are the protected categories for Massachusetts. Make sure your employees know how to report an issue. Make sure both that your policy is clear, identify who employees should report the issue to, and make sure that those people know how to investigate the complaints. We recommend regular training on it to make sure both the employees know where to go if they have an issue, and that the people that they're going to know how to properly investigate the issue. It's very important, and you want to make sure that it's handled correctly. So,
before you leave that, there is a requirement about posting the laws. And yes. I believe the MCAD has a poster.
The MCAD even has a sample sexual harassment model policy. And I highly recommend using their language because it's very clear about how it lays out sexual harassment and discrimination.
But there is some requirement that employers post yes. the applicable employment laws, and there's commercially available posters. Am I correct?
Mm-hmm, that's correct.
Is there a threshold for a size of employer?
For the discrimination laws, it's 6 or more employees is when it's applicable. But again, like we've said, a lot of those protected categories can still apply to smaller organizations. never hurts to post it and to make sure you're having training on discrimination and harassment. And then we'll turn to our final example. And so if you sit down with Henry to deliver his performance review and you announce that his overall rating is he really, really, really needs to improve and fast, he's crying. That's when he informs you that he believes his supervisor is unfair and he doesn't think that she likes older employees like him. What do you do now? So in this scenario, I'll play the manager. Mark, if you'll play Henry.
Oops. Ah, yes. Okay, I have felt that my supervisor is unfair for a while now, and this review really proves it. She has a problem with anybody who's older than she is.
Don't be ridiculous, Henry. You're just saying this now because you're unhappy with your negative review.
Absolutely not true.
Are you saying I should change the review? Or are you accusing your supervisor of being a liar? Take some responsibility for your poor performance. And that's end scene. So obviously that got a little more contentious. And what should the manager have said when Henry raised this issue that he thinks he's being treated differently based on his age? The appropriate response is something more along the lines of, okay, the company takes complaints like this very seriously, and I'll be in touch with you later or this afternoon to follow up. Communication is key, and you really want to ensure that employees feel that you're taking their complaints seriously, and you should be. They should be investigated.
Okay, then quickly, retaliation.
Very briefly, retaliation. So this is the last thing to discuss today. It often goes hand in hand with discrimination. The simplest way of putting it is retaliation is sort of the act of revenge. For an example, an employee complains about discrimination and then you fire them. That's illegal, and that would be a retaliation claim. So to set forth a claim of retaliation, an employee needs to show that they engaged in some sort of protected activity. That means they did something protected by the law, including complaining about discrimination. A negative action was taken against them relating to their employment, whether that's termination or demotion, and that one caused the other, that there's that causal connection. Because the employee took the protected activity, that's why they were fired or demoted. So most employment laws have anti-retaliation provisions, so make sure your policies also include strong no retaliation provisions. One thing that's really unique to retaliation claims is those claims can survive even if the underlying claim is without merit. So if someone brings a discrimination and a retaliation claim and you're able to prove as the employer that you didn't actually discriminate against them, that doesn't kick out the retaliation claim. That can still exist, and they can still say, but because I complained about it, that's why you fired me. And so they can really be the trickiest and most expensive ones to end up litigating. And so you want to make sure that you're not retaliating, you know what retaliation is. And this all sort of comes back to what Mark was saying earlier. It's important to document, and explain why you're taking the actions that you're taking.
Okay, I have one last question, Danielle. Are you okay with sharing the slides with the people?
Yes.
Okay, so we can have Dominique or Eric send out the slides to whoever was on the call.
Great.
Or to others who couldn't make it and would like to see it. Before we go, any other questions that you have that we haven't addressed? I guess not. So Danielle, I thank you so much. If situations come up and you have questions, you're free to raise them through Dominique and Eric. And if we can get you answers, we will. But stay out of trouble. You guys do great work. You don't need to be distracted by getting involved in employment law litigation. Many thanks.
Well, thank you so much, Mark and Danielle. The slides will be shared with those who attended and registered. There was a last question around sharing a sample of a handbook. But yeah, we really appreciate you all, and thank you all for being here, and have a great day.
There are, well, let me just, there are the National Council of Not-for-Profit, something like that, I believe has sample handbooks. And I know the fund is revising its handbook. I don't know what the policy, I guess it would be up to the board as to whether they'd be willing to share that with somebody. But if you do look at a sample handbook, make sure you go through it carefully. Not all samples are good or applicable to Massachusetts. Great. Thank you, everybody.
so
Have
much.
Thank you.
have a great day.